I do have skills that make me a nightmare for people like you.
Mr. Mount.
Good afternoon, Chair. The next witness is Rosslyn Noonan.
Thank you. Ms. Noonan, as you commence your evidence in terms of the Inquiries Act 2013, may I inquire of you as follows. Do you solemnly, sincerely and truly declare and affirm that the evidence you will give before this Commission will be the truth, the whole truth and nothing but the truth?
I do.
Thank you. Mr. Mount.
Good afternoon, Ms. Noonan. Just with some formalities. In front of you we have a copy of your statement of evidence, which is 94 paragraphs long with some appendices. Could you just confirm for us that you have signed that today and confirm it's true and correct to the best of your knowledge?
I have, and it is.
Thank you. In a moment, I will invite you to make any introductory comments that you wish, but could I just confirm that you are currently the Director of the Human Rights Centre at the University of Auckland School of Law, and you were previously Chief Human Rights Commissioner for a decade from 2001 to 2011.
That's correct.
And obviously your evidence, in light of that background, will have a particular human rights focus. But I understand you may have some introductory comments that you would like to make.
Thank you. Ena mana, ena reo, rawangatira tēnā koutou. Commissioners, survivors, advocates, Commission staff, Royal Commission staff, tēnā koutou, tēnā koutou, tēnā koutou katoa. I wanted to start by acknowledging the courageous, searing testimony we heard today from Beverly and Anna Sophia, and from those survivors who appeared earlier in this contextual hearing and those we're still to hear from. Whether in state care or abused in faith-based institutions, it's clear from their stories and from the response of the state and of the faith-based institutions to date that a massive constitutional, structural, cultural, legal and moral and behavioural changes are required if in the way we protect the human rights of our children and young people and those children and adults with disabilities who are in care. And the focus of my submission, perhaps slightly different from some others, is the state's response to the claims of abuse in care since 1999. So like Judge Beecroft, I urge the Royal Commission to interpret broadly Section 10.1 of the Terms of Reference in relation to its ability to consider matters after 1999. And just very briefly, the reasons I do so, there's probably two or three of them, is one, that how the state has responded to claims of abuse since 1990 reflect very much the reason why this commission was necessary. Because effectively, successive governments and agencies of the state sought to suppress general public knowledge of the abuse and violations that have gone on over many decades, and actually, in my observation, took a number of measures to try to prevent an independent inquiry of this nature being established. And the problem is that those same agencies will be providing advice to ministers about how to respond to this Royal Commission and its recommendations, and are already doing so. And so the extent to which, if their behaviour post-1999 is not, and I will be giving some examples of that, is not called into account, and if they are not required to acknowledge the extent of their responsibilities at the highest level for the persistence of the abuse over many decades, then I'm afraid no matter what you recommend won't make any difference. And I mean, this is the critical, this is looking at where power lies and what needs to be done to ensure that those with power are required to change and do in fact change. So, and that won't happen if you don't look post-1999, because they have assured us all too often that they've sorted everything. Bad things happened before 1999, but since, we've got it right, we've changed the law looks pretty good, and don't bother us. Just sort out the historic stuff. But as we know, and as we've heard from Judge Beecroft, in fact, the abuse does continue, but more importantly, there's no recognition. I think the abuses should be stopped, but it won't be stopped unless there's recognition of the systemic failures of those at the highest level of government and government agencies with respect to this issue.
In paragraphs 9 and 10, you have given us a bit more detail about your personal background. Are there any aspects that you would highlight for the Commission?
Well, just very briefly, when I was preparing this, I realised that in the early 80s, in the first half of the 80s, as an industrial officer with the Public Service Association, I represented social workers and assistant social workers. These were people working in the very institutions that we've been hearing how extensive abuse was. And later on, from 1998 until the mid-90s, I was the National Secretary of NZD Aotearoa, again representing teachers, psychologists, education advisors and others who were working with these children either in state schools or integrated schools which they attended from the residences, or schools attached to the institutions themselves. And so I am concerned that the Royal Commission actually hear from those people, because I think we know now that, and we know a lot more probably, about the impact that an environment of bullying, violence and intimidation has on staff, as well as on children and young people. And I'm not excusing staff in any situation where children were violated if they could have prevented it. But again, I think this is where issues relating to leadership, management, what we know is that in any institution, the tone, the behaviour, the environment is set by the leadership, is set by the senior management. And in the case of state institutions, that senior leadership was at the national level, in the government agencies, education, social welfare or MSD, health, as well as the heads of the managers of the institutions themselves. So again, if there's really going to be any change, and it's unlikely that institutions as a whole will vanish, even though ideally that might be desired, we need to understand what the mechanisms are that allow a culture of violence and bullying and intimidation to persist. And that means focusing on the management and the leadership, not just the so-called bad apples, which again has been the approach of the state to date.
I take it you would advocate that we hear not only from the people at those senior levels, but also from those who were at the coalface.
Oh, totally. I mean, I think you need to start with them because we need to hear what their experiences were, how they came to be caught up in some, in some very, very disturbing environments. And also, we do know that some of them tried to draw to the attention of Wellington what was happening. We know that now, and with no success. I mean, similar to the response to Accord, the centre chose to ignore the evidence that was presented to them about what was going on and did nothing about it. So, other than try to suppress and hide it, they did do that. So, and the other thing is that just, again, in preparing this, most recently I've chaired the Te Korowai Turea Whānau, which was the independent panel examining the 2014 family justice reports, reforms, and in that process, of course, what we discovered was that there was a whole raft of systemic issues across the family justice services, so that includes family court as a whole, but all the related services around it, none of which had been if adequately addressed. And those systemic issues are absolutely central to the considerations of this Royal Commission. So, and again, I mean, obviously you can have access to the Te Korowai Turea Whānau report, but particularly in relation to the system-wide issues that need addressing, and in addition to the failure to being totally monocultural and the failure to take account of te ao Māori in any respect, they were also not responsive to Pacifica cultural needs or to those of our new migrants. But to me, equally shocking was the fact that there was no systematic accommodation of people coming before the family courts with disabilities. And many of the family justice services, including the courts, but not limited to the courts, were not accessible. Basically, we discovered that hearing loops weren't regularly serviced and fixed, and there was no provision for asking people beforehand, formally, what support they needed to effectively be able to participate in the court proceedings, although we were assured, by judges that, of course, if they knew someone was disabled, they'd go out of their way to help them. So a totally inappropriate charity model, which should have gone out with the, disabled people shouldn't have to beg for something extra in order to get equal access to justice. And I think that the fact that that was still the case with respect to the courts, and I'm sure it applies across the board, not just to the family court, really reflects, in my view, the seriousness of the issues relating to disabled people, disabled children and adults who require significant care or in state care or other institutional care.
If we move to part one of your statement about paragraph 20, perhaps to introduce the topic, we've heard over the last 8 days in this hearing of the numerous claims of abuse in state care over the years. I take it during your time as Chief Human Rights Commissioner, you became aware of those claims and formed a view about the government's response. Would you like to introduce your views?
Yeah, I'll try to summarise them. So essentially what happened was that after the Justice Gall Lake Alice compensation process and the publicity that surrounded that, the media coverage, and I think we heard this from Sonia Cooper and Amanda Hill, what effectively happened was that a lot of people who had been in Lake Alice or in other psychiatric institutions in New Zealand and who had suffered appalling treatment in one form or another, came forward and said, well, we need to be treated in the same way. At the Human Rights Commission, the first case that came to us, I call Kelly's case, and she was a young woman who was obviously very naive, very young 21-year-old, committed to Lake Alice for reasons I can't go into, but she was actually placed in the adolescent unit. And she came to us because she thought that it was unfair that just because she was not, she was over the age, even though she'd been in the adolescent unit and been treated the same way as many of the young people had, there was evidence of the treatment of young people, including use of ECT and so on, that she couldn't be compensated for that because it had really damaged her life in many, many ways. Anyway, I won't go through, I'll summarise, what I see as the key characteristics that proved to be common to the state's response to virtually all these claims throughout. And first of all, the Ministry of Health and Crown Law simply, what the mediator who was working with her just said, promptly swatted the complaint away, claiming that they didn't even have to come and sit with her, come to the commission, mediate, because the Lake Alice processes were only for children, people who were children at the time. So they wouldn't even enter into mediation or listen to her. When we, and they claimed, of course, if she was 21, then she couldn't possibly be in the adolescent unit. Actually, when we were able to retrieve what records existed, for the most part they provided corroborative evidence that she had been in the adolescent unit, and there weren't many details of the ill treatment she received, but there was enough to suggest that it had gone on. And we took those back to Crown Law as evidence that they should come to, the party and mediate with her. A Crown Law officer informally met with her, but nothing came of that. Just to say that the following that, she couldn't face going public over what had happened to her, which is why she didn't join any of the class actions that were being put together for other Lake Alice patients, and she didn't feel she could go to the Human Rights Review Tribunal on the age discrimination claim that she'd come to us with, for the same reason, that she would have to publicly disclose what had happened to her. But what we did do with her instead was help her put together her story in detail, with her records and so on, which she took to the Confidential Listening and Assistance Service. And she did find that experience affirming. Not closure, which goodness knows how anyone thinks there would be closure, but certainly that was a positive experience. But the key characteristics, as I said, the unwillingness to look at a non-adversarial approach to dealing with these claims, the difficulty in accessing her records. We did manage to get some. I did actually at one stage myself meet with the then Deputy Secretary of the Ministry of Health, and I tell you, New Zealand's public sector records, they've been subject to more fires, more floods, worms, other things that have affected them and caused surprising and usually very specific files to disappear. And we were given all sorts of reasons why her records were so intact. But fundamentally, and this is again what I found hugely problematic, was a complete lack of empathy for her situation until she went to the confidential listening and assistance service. And it was as if the government officials, the Crown Law lawyers, the Ministry of Health lawyers, as if somehow they had a stake in proving her wrong, in dismissing her claim, as if there was, I couldn't understand why, and given that this had happened a long time ago, they weren't personally responsible. I don't think there would be anybody left in the Ministry of Health who, would have been responsible at that time. And so why they needed to be so denigratory and dismissive of her, and and we know, and that attitude persisted.
Just to refresh people's memories, we've heard that the abuses at Lake Alice were sufficiently acknowledged by the government that I think a $10 million compensation fund was created, and the report of Justice Gallen condemned in the strongest terms what had happened there. So there was no secret about the existence of the abuses. I take it that's the background to your concern about the response to Kelly.
Yeah, because, clearly, even on the basis of the limited records that we were able to access for her, it was pretty clear that she was there at the time when the abuses took place, that she was almost certainly for a period in the adolescent unit, given the staff that she could identify who were in that, who were staffing that unit, etc. So
your hope might have been that she could push on an open door rather than have a door slammed in her face.
Yes, exactly. And the expectation that there would be, I think it was definitely in the state's interest to to recognise that these abuses had gone on and to find a way to face up to them and provide some redress. And certainly in human rights terms, that's what was required. New Zealand had signed up to the Convention Against Torture. There was clearly inhumane and degrading treatment, etc. But it was like, no, we're going to deny them, or we're going to minimise them, or we're going to try and suppress them.
Did she ultimately have any compensation?
And unfortunately, we haven't been able to track down the final outcome, because my recollection, but it's, and I've sworn to tell the truth, so that I might be wrong. But my recollection is that eventually, because there was a kind of a health, the Crown Health Financing Authority did do a kind of a class settlement, and that she did receive something in that process.
Further down the track.
Much further down the track, yeah. But that may not be the case, and the mediator who worked with her was very unsure when I tried to, and I haven't had a chance to really. The records now, the Human Rights Commission records, will be well stored somewhere and would take a huge effort to it. So she may have got something, and I want to acknowledge that. But anyway, and so, yeah.
Shall we move to access to records, perhaps, which is from paragraph 32 of your statement?
Yeah, so as I say, one of the things that's been consistent in the terms of the state's response to all of these cases is either very poor or lost records, and certainly when care leavers have sought to access their records, they've had a hugely difficult time of it. And often, I'm aware of care leavers who received, the first time they asked for their records, they received records that were redacted virtually every page, like 100 pages and hardly a single non-redacted sentence. And given that the records, all of the mechanisms that the successive governments put in place to respond, put in place in the 2000s to respond to claims of abuse, all required the claimants to be able to produce records that proved that they were there at a particular time, but also not only that, but that specific things happened to them. And if it wasn't referenced in the records, the tendency, and again, I'll leave it to Sonia Cooper and Amanda Hill to provide you with a lot of that detail, but the outcome was, well, we don't accept your claim because there's nothing in the records. So, and that affected the compensation levels. One of the things that we did as part of, as we were advocating for an independent inquiry, and this was, prior to the change of government, so when in the national government, the Human Rights Centre, supported by the New Zealand Archives Professional Association, organised a round table about the records, and that involved people from National Archives, but also from a number of the faith-based institutions in terms of what records they had kept. As well as the Department of Internal Affairs, etc. What I've provided for in the submission is the sort of detailed summary of what came out of that day. And I'll perhaps just highlight some points from it. But so basically, care leavers generally found that the only personal records that existed of their childhood are held by government departments, who often choose to redact much or most of the personal information about the people that they were surrounded by in childhood. And those redactions were often also inconsistent. And if I can just tell you, one of the people who participated, a care leaver, and I hope she might come before the Royal Commission at some point, but at the time of the symposium, she was 79. So she'd been in care and put in foster care, as a young child, and because her mother was deemed to be developmentally or learning disabled to an extent, and it turned out that she'd been it was later accepted that she'd been fostered into a family where the mother turned out to be seriously sort of psychotic, but anyway. She said, before I die, I'd just like to know everything that happened to me. And endlessly, request after request, complaints to the Ombudsman. At that stage, so 2017, she had still not received a fully unredacted copy of her records. Now, what possible harm could a 79-year-old woman do to anyone who's mentioned in those records? Because, most of them would no longer be alive at any rate. And, I'm putting some emphasis on this area because I think it's something that probably the Commission needs to deal with sooner rather than later. There's the fundamental question of who owns those records. And if you think about it, virtually every other record made about us here in New Zealand, whether our health records, school records, credit records, they're ours under the privacy legislation. We can ask for them, we can get them completely. But here, children who are in state care cannot get their records. And then when they do get them, and I think we heard this from one of the survivors, they only put negative stuff in. And then very recently I've heard that people have had experience where where there has luckily been maybe some school photos or whatever, that the photos have been redacted on some spurious privacy grounds. Now we know if you take, so only the care leaver, his face has been left. I mean, what sort of thinking is doing this? So, the care leavers themselves, and I've attached for you, they're following the symposium, and they'd never done this before, but they were supported to make a submission to the Oranga Tamariki legislation on what should go into that legislation in terms of the records. But just to summarise what they themselves said in that submission, they said that, they provided details of accounts of insensitive, disrespectful interactions at the point of handover. So that's stuff that was happening in the 2000s, and beyond. Insulting judgmental opinions, redactions which are neither consistent nor fair, inaccurate, incomplete information, and omissions. And then they go on, and I think, again, I would urge you to look at what they recommend about what they see should be available to care leavers in terms of records from now on. And I think that what they propose is very practical, reflects a human rights approach in a sense that those who are most affected should be able to have a say about what should happen. So here they've done that, and really gives voice to the children in care about the sort of records that would be appropriate for them. So as I say, I would like to ask that this be looked at early on, so that people no longer seeking their records no longer have to go through the sort of hoops, and it may well come down to the issue of who owns these records. And again, at the time we did have a look at the legislation, and it's difficult to see on what legal basis the agencies concerned claim that they own the records, as opposed to these being personal, records which ultimately the ownership should be with the person about whom they are. And obviously there's always has to be an exception if there was a real threat of violence, if somebody found out the name of somebody who they felt had mistreated them, maybe that, but generally that's pretty rare.
Now, just for the record, the full submission from the Care Leavers Association is Appendix 2 of your statement, so the commissioners will be able to look at that in their own time.
I don't think the Oranga Tamariki legislation sufficiently took account of their submission, so that's an area that definitely needs change.
Shall we move now to the Crown litigation strategy from para 39?
Yeah, so obviously amongst, if we, I'll just go back for a minute. If you think about the Crown's response to claims of abuse, the Crown summarised their approach as, and in paragraph 22 of my submission, I'm quoting directly, at a systemic level, allegations of ill treatment in a given institution.
Just pause there for a second. Mindful of those who are having to interpret this for others. Yep. Just do it slowly, sorry.
Yeah. Okay, so paragraph 21, I quote the government's response to, the government's own summary of how it's responding. And it said, at a systemic level, allegations of ill treatment in a given institution are thoroughly investigated. Well, I think we've heard enough to know that we're not sure when that thorough investigation started, but and then for individuals who raise allegations, court and police procedures have been supplemented with a confidential listening and assistance service, which can provide support and other assistance, and with an alternative resolution process, which can provide compensation, apologies, and other remedies. And in a very self-satisfied summary, they say, the result is an integrated and comprehensive approach to addressing such allegations. And if you didn't know anything about it, and you looked at the list of what they provided, so the confidential psychiatric forum, the confidential listening and assistance service, the Ministry of Social Development's care, claims and resolution process, the Crown Health Financing Agency, civil litigation, judicial settlement conferences, direct negotiations, and criminal procedures. It sounds like, kind of they had it covered. And that's what they sought to present internationally as well as nationally. But each one of those, while they had some positive elements, had very, very significant flaws. And I guess we start with the Crown's litigation strategy. So
the first thing you've talked about at 39 is the Atkinson case, which is a reasonably well-known case, but perhaps you can highlight for those who are not so familiar with it.
Yeah, so this was a group of parents of severely disabled adult children whose adult children had been assessed as eligible for payment for care because they needed very substantial levels of care, personal care, and whom the state would pay anyone to provide that care except family members, direct family members. And in the case of the 9 plaintiffs, all of them had tried alternatives, in some cases tried out-of-home care, in other cases had tried home-based, but like stranger home-based carers, and all of whom had had serious problems, not least of which was because the adult children were so severely disabled, people didn't stay for very long. I mean, if they were lucky to get someone who was, and then they were lucky to get someone who was sufficiently skilled, it was such a demanding responsibilities that there was constant churn. So, at any rate, the thing was, these families came on the basis that there was family status discrimination, which is unlawful in the Bill of Rights Act, the Human Rights Act. And once again, the Human Rights Commission, we tried always to find solutions, because we accepted that, complex environment, the Crown, had very real resource constraints and other considerations. But the human rights approach says, look at all of those with human rights involved, and how can you provide for them without derogating from the human rights, but obviously taking into account, the real life, complex issues. And in this case, the Human Rights Commission had developed, in cooperation with the Office of Disability Issues, so the government agency responsible, an approach which formed the basis of a cabinet paper which provided that family members could be paid providing they underwent the same checks that non-family members underwent, and they were prepared to sign the same contract. So this was no question of, risk to the government's finances at all. Everything, was kept within a controlled framework. And just before, it was on the cabinet agenda, and when it went onto the cabinet agenda, it was pulled by the Minister of Health and the Ministry of Health. And so rather than even come back and say, well, there's issues here, we need some further discussion, they took an extremely hard adversarial line that resulted in the families concerned having to go through the Human Rights Review Tribunal, the High Court. So they won at the Human Rights Review Tribunal, very, very detailed decision. The Crown appealed, they won at the High Court. The Crown appealed, they won at the Court of Appeal. In this process, two things. After the High Court decision, when we were going to, we'd been approached by the media, I had been approached by the media to give the Commission's response, as had the Minister of Health at the time, and this was Tony Ryle, that was the national government, and the Minister rang me to say that he really wanted to warn me that these parents were rip-off artists. They were just trying to scam taxpayers, and that I should be very, very wary of them because, evidence was going to come out about how they'd been defrauding the system and so on. I was able to tell him that actually I personally knew them. I knew that was complete rubbish. I knew where it was coming from, and that if he went public with that, he would be the one who didn't look good, that these parents were salt of the earth, and while they may have made the odd mistake, it had only ever been desperately trying to do the best for their disabled adult children. The Minister chose not to go on television, but did issue a statement saying that he respected the parents, and but that was typical. Now, these cases went well over 10 years. It took to come to an end. But the other thing the state did, and again you've heard this in respect to abuse and care cases, the state used all its powers to I don't even know what the right word is, but to really review every aspect of these parents' lives. And they found in one case that one of the parents had used money that she was given for respite care, I think to put a fence around their little property because the disabled adult desperately wanted to have a dog and they couldn't have one without a fence. So she did use money for respite care for the fence. When MSD and Health discovered that, they actually charged her with fraud, which was an outrageous thing to do. So it was part of them really seeking to intimidate the people who had the gall to bring a case against the state. Without going into all the details, she went before, I think, a Wellington District Court, chose a jury trial, and the jury found her not guilty in about 30 minutes. Now, the thing about that, because I'm going to come on to say some harsh things about the courts, but the thing about that is it's almost certain if that had been a judge alone case, he would have found her guilty, because theoretically, or not theoretically, strictly speaking, she was guilty. She did spend the money for something other than it was given to her. But the jury could see beyond that to what was justice. And we came to see this very hardball attitude. In the other case...
Just before you do, have you summarised at 46 the key elements in your view of the Crown's response?
Yeah, so rejected the option of a negotiated settlement in favour of litigation, used every resource available to the state to zealously defend their complaints, attacked the character of the complainants rather than taking a principled approach to litigating solely on the issues, and ultimately, and this is probably almost the worst, when they finally lost with a 5-bench Court of Appeal, under budget secrecy and urgency, they introduced legislation which overturned the court's decision, largely overturned it, and removed human rights protections for people in that situation, so there could never be another similar claim. So, if this had been any other country where a government had acted like that, we would have regarded it as, an outrageous breach of human rights. This was New Zealand. So, the current government has a commitment to amend the legislation, restore the human rights entitlements, but it hasn't happened yet, as far as I'm aware.
Shall we move then to the White case, which is something that Keith Whiffen talked about, and Sonia Cooper and Amanda Hill. So we have some information about the White case, but would you like to summarise your perspective?
So I won't go into the detail because you know what it was about. It was actually when I read this that I realised that the decision in this case, that I realised that the Human Rights Commission had a responsibility to get involved in this area, because effectively 2 young boys who had certainly been severely, assaulted, etc., abused by their parents, and were taken into care, but then were further abused at Epuni and Hokio boys. And the decision of the court acknowledges that. It acknowledges the bullying, it acknowledges the assaults by staff, it acknowledges the derogatory language used by staff, and it acknowledges that one of them at Hokio was sexually assaulted by the cook. So there's no question that actually happened. But what shocked me was the decision in this case that the High Court found that basically, because damage had been done by the family as well as by the state institutions, that there was basically no way that you could work out which was which. And so, taking into account statute of limitations, which the Crown invoked, and the ACC legislation, there was no compensation. But I think even worse, if you read the decision, there's various points in it, and I urge every member of the Royal Commission, it's like 100 pages or something, but you should read it, because it illustrates the extent to which the judge himself kind of treated them like criminals. And certainly if you read the transcript, the Crown's counsel treated them as if they were the criminals, not the victims, and subjected them to the same sort of cross-examination, the same denigration that they do of alleged criminal offenders. And at one point, for example, if you read the decision, it looks as if the judge even is kind of blaming the boys for the fact that they were assaulted and bullied and things, because they were the way they behaved, and then their behaviour was difficult, etc., etc. And in the transcript, at one stage, the Crown counsel, who to her shame was a woman, was suggesting that the boy who was molested did so because he liked to get cigarettes. So there was mutual benefit. He was 12 or 13. The judge intervened at that stage and said, "Where are you going with this? You're not really suggesting consent, are you?" And And she said, oh, no, it'll soon emerge. But he didn't stop her. You know, I mean, this case, you know, a psychiatrist was called by the Crown to give evidence that because there wasn't a lot of publicity about sexual abuse in the 1970s, if you were a child sexually abused in the 1970s, it wasn't as damaging because there hadn't been media coverage. So there was it was the publicity that caused people to think they were damaged. You know, and a number of other things. But I think it showed conclusively that while the court, and I'm not questioning, you know, the finer legal decisions of the judge, but in terms of justice for these men who had been severely damaged, there was none. And I also, you know, the other thing that struck me is I realised, of course, and again I think this is a factor you have to take into account in looking at why we allowed this abuse to continue for so long, is that those in positions of power, whether judges, Crown Counsel, senior officials in government agencies, still come from seriously privileged backgrounds for the most part. And the ability to even begin to intellectually kind of grasp what happened to these children and young people was clearly beyond them. And all they saw was the outcome, which, as we've been inclined to do, we then blamed on them. They got into drugs, you know, they committed crime, they ended up in prison. There was something fundamentally wrong with them. So you can't really, you know, be too concerned about what happened to them previously, because clearly there was something wrong with them that people treated them like that. And that is what has to change. You know, it really does. But this was, you know, so we, in a sense, both the Atkinson's case, the courts came to the party because actually, to be honest, the discrimination on the basis of family status was, you know, was so blatant that I don't think they could do anything else. But they did, and that was good. But as far as the White case, it's totally highlighted the attitude of the state to people who had the cheek to claim compensation for what had been done to them. And it was at that point that you know, I recommended to the Human Rights Commission that we needed to monitor the state's response to see if it was meeting international human rights standards. Having done that and made that public, I have to say that what I was then faced with was senior officials coming up to me and telling me, off the record of course, that I should be very careful, you know, not to get too close to Sonia Cooper and Cooper Law, because she was basically just out to make money out of legal aid by encouraging these people to take claims which, you know, and really raising their expectations when she shouldn't be doing that. And I know from the staff member who worked on this, that who worked on the Commission's review of and monitoring of the state's response, that he got several of those warnings as well, probably with more graphic detail than I got, because I basically shut them down quite quickly. But so this was a whole. It was a strategy, and about 2 years ago, before the Royal Commission was established, and while, you know, we were advocating for its establishment, and I was quoted on the media at some point, I was contacted by a former senior official who said he was ringing me to apologise, to say that everything I'd said about their behaviour was absolutely correct, and he was part of the interdepartmental group that was responsible for developing the strategy. So, you know, that was the Crown's response. And to be honest, my fear is that apart from superficially, it hasn't necessarily changed, and that the Royal Commission is going to have to be incredibly careful and skillful in terms of, what you take from the government agencies about this whole, because we can see how self-satisfied they were with what they provided. And after this government announced the establishment of the Royal Commission, they produced a paper that showed that really it wasn't necessary because they'd fixed everything. So so I don't know if they've now changed their mind, but...
Just before we leave the White case, you didn't have this information at the time, but of course I believe an inquiry last year found both Crown Law and MSD in breach of the Code of Conduct for their use of private investigators in the case, with the potential use of surveillance against the white claimants. And I take it that would be consistent with your statement at 50, that the Crown strategy was to use any means within or outside the legal toolbox to defend the claims.
Yeah, and that's obviously, they did that with the Atkinsons as well, in the way they surveilled those families or tried to find dirt on them. It was the same, the same strategy.
Yeah. Now, we will, of course, come back to the White case, I'm sure, as part of the redress examination.
Yeah.
So,
And I think what it raises is the whole issue of what was the litigation strategy and who was responsible for it. And I think somebody, Judge Beecroft, raised at the very beginning of his submissions the whole issue of privilege and what's protected by privilege. And I'm conscious that Crown Law has insisted that this litigation strategy was protected by privilege. Well, I think if the Crown is going to be open and fully transparent with this Royal Commission, it needs to provide the litigation strategy that it used in the 2000s, but which seemed to, have continued without much modification, until recently. And you need to get that. And because I think it also gives rise to the question of to what extent did the Attorney General, who for most of this would have been Michael Cullen, to what extent was he briefed, and to what extent did he specifically sign off on this sort of behaviour? Because mostly I think that the senior officials, the Crown Law officials in the Ministry of Health and MSD should be held to account. But I think the politician, there's a question about how much and at what point, particularly the Attorney General, Minister of Social Welfare, knew and approved of the particular approach, given how drastic it was.
The next section of your statement addresses the non-legal mechanisms for responding, including the confidential forum for former psychiatric patients and the confidential listening and assistance service. We have heard about those to some extent already. Is there anything you'd like to highlight?
So I'll just highlight the two things. One is I think they were set up, well, in the first case, the psychiatric forum was definitely set up to try to stave off claims of compensation following Lake Alice, when so many accounts of abuse in psychiatric care came forward. And I think if you look at the terms of reference and the extent to which nothing could be made public, even if people were prepared to have it made, obviously you want to provide really genuine confidentiality, but actually these terms of reference really were intended to suppress any general knowledge of widespread ill treatment in the psychiatric services, and then subsequently even tighter more restricted terms of reference applied to the confidential listening and assistance service. And, you know, people will tell you that I'm not necessarily, you know, I don't necessarily think we need lawyers all the time for everything. But I think it was shocking that the provisions, the terms of reference for both these services prevented people who came before them from having a lawyer with them if that's what they chose. Lawyers were banned. And I mean, again, you have to ask why. You know, so the sort of, the positive, you know, the seller, the sort of PR version will be because, you know, we wanted it to be all pally-pally and not all legalistic and whatever. But actually, in reality, again, it was, I think, much more to try to prevent anything that might be useful in claims against the Crown emerging in that process. So that's what I would say. I would say, look, I admire the job that was done by both, and particularly by the confidential listening and assistance service, who went to huge lengths to get people's records, to provide support, you know, to get them decent support, etc. So the people who, Judge Henwood and the team that she worked with, I mean, they did a remarkable job, but that was in spite of, not because of the process. And again, the intention of the state was clearly to keep all of this out of the public eye. Again, which is why this Royal Commission is so important. Because, you know, I've had care leavers say to me, survivors say to me, the thing is, nobody knows what went on. No, you know, no, people in my family don't know. And if, or friends or people in my workplace, and if I was to tell them, they would think I was lying, or that couldn't possibly be true. And so, you know, for lots of survivors, just knowing that the wider community understands that a whole lot of abuse went on, and, you know, and people were damaged by it, you know, so they don't have to say, well, this is exactly what happened to me, but just like I was there at that time. You know, and even today I've heard of a case where only because of this Royal Commission, you know, a family's discovered that their family, one of their family members was abused in an educational institution in that instance. So, you know, this is why it's so important. Yep.
Would you like to move on to monitoring mechanisms, para 64?
Yeah, so again, Judge Beecroft has spoken about the monitoring mechanisms. That they were used as an excuse to make 1992 the cut-off date for the confidential listening service, you know, the forum and the confidential listening service. And yet, not one of those monitoring mechanisms is or has been appropriately resourced really at any time. So there's been a history of establishing monitoring mechanism, and I have to say I do want to acknowledge that in its very early days, the Human Rights Commission, so it's the early 80s, was the only state agency, or state institution, to respond to the Accord evidence, and did undertake, you know, did undertake their own review and published a report about it, which I have to say the judge in the White case thought wasn't worthwhile his even looking at. He would prefer to have a report from the government agency concerned. Even, you know, anyway. So, yeah, so I think Judge Beecroft, I mean, I think the issue around why the existing monitoring mechanisms weren't more effective. And obviously, for the most part, they were really only established late 80s, 90s. But I'd have to say I'm not sure that they've been hugely effective
or as effective as they should be since then. In fact, we know there's some evidence that they haven't. But I think it's more than just saying, so we need to establish another one on a slightly different basis. I mean, I think, the Royal Commission and those of us who've been involved in monitoring mechanisms need to give quite a lot of thought to what's worked and what hasn't. What do we need to do to really create a critical mass in a small country like New Zealand? A whole lot of separate, siloed institutions, I think, have a great deal of difficulty delivering. And while I was Chief Human Rights Commissioner, and again this is on the record, and raised at the time with the Children's Commissioners of the day, I did express concern about the extent to which MSD restricted and put pressure on the Office of the Children's Commissioner. And I thought most appropriately it should become part of the Human Rights Commission. Obviously still have a completely, the Children's Commissioner and be, properly staffed, and it wasn't properly staffed at the time, but, at least, as staffed as it was at the time within the Commission, and that would have, because the liaison department or ministry for the Human Rights Commission was the Ministry of Justice, and whereas the Children's Commissioner had to, had the mandate to investigate child, youth and family, and etc. But MSD was their liaison department. So it was problematic. That relationship was really problematic. And secondly, national human rights institutions, of which the New Zealand Human Rights Commission is an A-accredited national human rights institution, they have to meet international standards of independence, and those are reviewed every 4 or 5 years internationally. And so there is more scrutiny of the extent of the independence than there can be of an Office of the Children's Commissioner. So I think there's lots of things to explore. I mean, I often say to people who say Parliament's the answer, that actually, of course, Parliament is always controlled by the government of the day. Occasionally, Parliament shows that it can do more, but mostly in New Zealand, the outcomes you get from Parliament are what the government of the day wants. But I think Judge Beecroft has raised a very important issue, and as I say, it is something that the Royal Commission does need to consider.
Shall we move on to the draft report prepared towards the end of your time as Chief Commissioner? This is from about 68 of your statement.
Yes, and I'm kind of conscious of the time. So I've provided the full draft report as an appendix because it is the one actually contemporary account that had gone through various iterative drafts with all of the agencies involved. So the information that's there is factually correct at that time. All of the, and I do want to say and acknowledge the work of the Commission staff, that through the process, and we had good engagement with MSD, less so with Education and the Crown Health Financing Agency, but just the process of monitoring and engaging and having discussions with them led to some strengthening, particularly of the MSD process. And I'll just give one example of that. So again, the Crown was able to use its resources to contract qualified researchers to undertake a research on what were the rules, regulations covering the various institutions, what was the situation in those institutions, in the 60s, 70s, what was the practice of the day. And initially, that information was denied to the claimants on the grounds of, guess what, legal privilege. No, that was for us. So the Crown And when you remember that most of the claimants were poor, most of them were legally aided, none of them would have been able to afford equivalent research to be able to challenge the research. So it was an obvious example of complete lack of justice, and we were able to, point this out. And eventually, MSD made that material available, I think, on its website to everybody. So that was just one example of kind of making the process at least a bit better. But as the review we undertook concludes, all of the processes had some flaws, and I've talked about the flaws in terms of the terms of reference for the confidential listening assistance service and the forum, the psychiatric forum. In terms of the MSD care claims and resolution, the Crown Health Financing Agency, and in education, there was no independence at all in the way in which those services operated. Now, the staff involved in them were outraged that we should suggest that they weren't independent. They were doing their best, but they were staff of the agency against which the claims were, and they weren't going to be doing that job forever, and they had to look to their future prospects. So even if we allow that, and I do, that they were trying their best, the fact of the matter is that they couldn't possibly be seen as independent by, people who had been abused by parts of that agency in the past. I mean, although some people had, not a bad experience, and they were quick to send us examples of thank you letters from people who had found it helpful and gratefully accepted the very modest amounts of compensation that were provided. It wasn't independent. It wasn't even impartial, at any rate. And there were other issues associated with them, but those are all in the report. So, but what happened was, and I feel extremely responsible for the failing in this respect. But what happened was, when we sent the last draft around to say, right, we've incorporated everything you've told us, and we always sent copies to Crown Law, but they'd never responded. In this instance, they came back saying, oh no, well, you can't publish that report, it's full of mistakes, and you've made errors in interpreting the international human rights obligations, etc. So, cut a long story short, I organised a meeting. I offered to have a meeting with the Attorney General. Instead, a meeting was set up with, at the time, the Deputy Crown Solicitor and the person in charge of the litigation strategy, etc., for the Crown, at Crown Law. Anyway, there were no factual errors. The two mistakes, according to Crown Law, was one that we said there were systemic issues that merited an independent inquiry, because none of the processes actually looked at the systemic issues, because they were looking at individual cases and trying to deal with those individual cases. And I was really surprised at this, because I thought it was so obvious by now. There was enough evidence of the type of claims that were coming forward that clearly there were a whole raft of systemic issues that needed to be looked at. And not least, management, monitoring by National Office of what went on in the regions, etc. A whole lot of things. But when I said, what do you understand by systemic issue? And I was told that, well, there's not a shred of evidence the national office of any of these agencies ever sent out any instructions about abusing children or mistreating them or inhumane punishment or... No, they had done nothing. They had certainly not, there were no systemic issues. There were only issues that related to bad people in individual institutions at the local level. So that was one thing. The second thing related to the Convention on Torture requires an impartial process. And so they argued that we said there was a need for an independent process, and and we were, as I say, misinterpreting the international requirements. So anyhow, I think that in order to get it published, we tweaked the wording with respect to independent and impartial, re-emphasised the fact that taken as a whole, there were some good parts to all of these different, so putting in the positive, but that still, our recommendations were still that there needed to be both, an independent inquiry and an independent process for compensating people. But that was right at the end of my term as Chief Commissioner, and so we hadn't managed to have it published before I finished. In fact, the draft you have is the one that was ready to go to the printer as I finished up. And I handed it over to my successor with a view, which I said, if you prefer, it can be published in my name, so you don't have to be responsible for it, or it can go under your name with, but acknowledging that obviously it was done beforehand. And before he had a chance to do any of that, he received some very intimidating correspondence, I should say. I'm just trying to think of the right word for it, from the then Attorney General, who was Chris Finlayson. And as a result of that correspondence, the report was put in the bottom drawer and, never saw the light of day until Aaron Smale, the journalist who uncovered so much of this, was able to OIA it and put it back in the public arena. So again, I think that again, without necessarily wanting to single out, a particular Attorney General, because I suspect that whoever had been there might have written the same, because of what I see as the overall trend of the government's responses. I think, again, using any means to repress the government's inadequate and failure to respond appropriately. And whether it's, I think the public service is permeated with unduly risk-averse. I think that's, and again, the politicians have to take some responsibility for that, not just the agencies. But there's a whole, there's a number of issues. But I think the report has still has value in terms of, and when you think, again, from the evidence that Cooper Law have provided, Cooper Legal, and some of the survivors, in terms of the length of time it's taken to get their cases dealt with. We're 2019 now, and some of the cases, that were there in 2011 are only just being resolved now. So it's a shocking, we should be shocked and ashamed that that's how long it's taking. Actually, the Convention on Torture does require sort of speedy response, and so I don't think even Chris Finlayson could claim that met that requirement. So.
Now, I don't want to limit you in any way, but I'm mindful of leaving enough time for the commissioners to ask you questions, as I'm sure they will want to do. Is there anything else you'd like to say on that topic before perhaps you could summarise your
Yeah.
conclusions in part 3?
Yeah. No, I think that's enough, really. I mean, of course, I'm happy to answer any questions, but...
And of course, we will come back to many of these topics in later hearings. So.
Exactly. So, well, again, I just want to reiterate my really extraordinary respect for survivors like Keith Whiffen and others whose persistence and advocacy and courage really, led to, two journalists in particular, Aaron Smale and Mike Wesley Smith, undertaking such a highly professional job, that the whole issue of claims of abuse and state care, but also, faith-based institutions, came back onto the national agenda. And I mean, it really did. And also, because as I've said to you, in terms of what, how Sonia Cooper was smeared to me, I really think, she deserves huge respect and admiration for persisting. And again, those, you will have heard her, the evidence that she gave and the difficult times they went through, but persisting, because without her and one or two other lawyers, again, we wouldn't be aware of what's been done in our name. And I think the efforts of the Human Rights Commission up until 2012 and then from 2016 also contributed, and I wanted to acknowledge particularly Commissioner Paul Gibson and Race Relations Commissioner Dame Susan Devoy, who in very difficult circumstances, again, advocated that something needed to happen and persisted in that advocacy. I think I've probably said repeatedly, the state has not hesitated to use its powers and greater resources to oppose and minimise the claims of those who've been abused and ill-treated. And courts have not been able to right the massive imbalance between the state and the survivors. I've already said my concern about the extent to which government agencies oppose the establishment of this Royal Commission. But they succeeded, you see. I mean, they didn't succeed completely, but they did succeed in getting the terms of reference formally limited to 1999. And I think the challenge for this commission is not to perpetuate that imbalance. And it's really my observation and experience over many years that if government agencies and their ministers are not held to account for their failure since 1999 to meet New Zealand's human rights obligations, that God, I don't know what I've done with this, but if they are not held to account, then nothing will change. That's the thing. They will have succeeded. They're picking up little bits here, they're tweaking this and that. And I mean, it's good to see some response, but actually a lot more than tweaking is required. And when we were doing the review of the Family Justice Services, I mean, what became clear to me was that there's still within the government sector, there is no regular systematic incorporation of New Zealand's human rights standards into the development of legislation, policy and practice. Despite, the Bill of Rights Act, reviews that go to Parliament in some very limited circumstances, there's virtually nothing else. And so, actually, and this was true for the Convention on the Rights of the Child. I mean, these are conventions that, they're conventions that have been in, that we've ratified many years ago, but still are not regularly taken into account. There's sometimes somebody will discover them, when the policy or the practice or the bill's already drafted, by which time it's usually too late to do anything substantive. But that's got to be an absolutely fundamental a fundamental requirement that we mainstream the human rights standards that we often led the negotiations on with respect. We were very actively involved in the development of the Universal Declaration of Human Rights, something we can be proud of. And of course, the New Zealand diplomat led the negotiations on the Convention on the Rights of Persons with Disabilities. And yet, despite us accepting as a state, accepting international acclamation and awards for that role, we still haven't mainstreamed the requirements of the Convention on the Rights of Persons with Disabilities, even at the most superficial level. And that puts at risk every particularly severely disabled person who needs significant levels of care, for example. So that's the context in which you're working, in which this Royal Commission has been established. But can I just conclude by saying that I think these 2 weeks of contextual hearings have really already begun to make a difference. So thank you for the way you've organised these, and I'm looking forward to more of the same in the next stage, because they are complex issues. But having this public profile and people beginning to hear what goes on I know from comments I'm receiving, is already beginning to have an impact. So thank you.
Ms. Noonan, thank you very much for your evidence. Please wait there, because there may well be some more questions. And Mr. Chair, if I may just check with Rachel Opie, who assisted with the drafting of the brief. Thank you, Mr. Chair. I haven't been advised by any of my colleagues as co-counsel, as counsel for participants, of any questions, but I'm sure they will bounce up if there are. Otherwise, it's a matter for you as Chair whether there are any further questions.
Thank you, Mr. Mount. I'll go through the motions in any event to first of all ask if any counsel, despite the practice note to which Mr. Mount has referred, is there any counsel who wishes to address questions to this witness, Rosslyn Noonan? There isn't. Okay, thank you. I then provide that opportunity for questions to be asked to my colleagues. Can I begin with you, Ms. Alofivai?
Thank you, Mr. Chair. Ms. Noonan, look, you have provided such a full and concrete brief. Can I just thank you for that evidence? You've actually answered the questions that I had in your brief around the level of transformation that's actually required, and actually where the power lies, and ... Thank you.
Thank you. Mr. Gibson.
Thanks very much, Rosslyn. That was incredibly powerful and comprehensive. I'll stick to questions in areas I wasn't involved in. You talk about the need for fundamental change about how the human rights standards get integrated into legislation, policy and practice. Earlier in the contextual hearing, Moana Jackson talked about the need for constitutional reform, constitutional transformation over a period of time, including Te Tiriti and the international human rights standards. How do you see that joining up?
Well, I mean, I agree with Moana completely. I think we do need, some very significant change, but I also think that the thing about New Zealand is we tend not to make kind of dramatic changes. So I think the challenge for the Royal Commission is what really substantial evolutionary changes, which will then lead on to other things, can be recommended and can be encouraged and developed. So, I mean, I think, I think that's the answer. But a lot of it, I do think there are fundamental changes within the state sector. I think, the whole development of, I won't say devolving power, I would say sharing power with iwi Māori. I think we're seeing some maybe very tentative steps towards that in one or two very limited places, but that needs to be a continuing approach. And I think that within the state sector as a whole, there needs to be a review of the principles that guide the state sector and that guide, it seems like the public element of the public service has vanished, and that public servants, and and they're doing what they need to do to survive, but they're seeing their only responsibility, because don't get me wrong, of course they are responsible to ministers and they're responsible for implementing government policy, but they're seeing that as their only responsibility and not their responsibility to the wider public. And I don't think, apart from the Secretary of Treasury, I can't think of a single senior public servant these days that you will hear a major think piece about where things should be heading. And yet, if you look back to some of the periods of really great change in New Zealand, whether in education, somebody like Dr. Beebe, or if you look at a Secretary of Justice like John Robson, you can go through and identify public servants who shared thinking to help generate discussion, whereas now you basically have people who are scared to recommend anything that might give rise to controversy. Now, that's not just their fault, that's also because of the way politicians are operating and ministers are operating. But I think it's really dangerous for us, particularly in an environment that's so complex, where as a society we face so many challenges, and there aren't simple answers. That's the thing. There isn't like a magic wand that you can wave and say that'll fix it all. There isn't. So we need to have an environment where robust discussion is welcomed. But we also need to have an environment, what shocked me personally has been, as I said earlier, the lack of empathy that I've witnessed in senior public servants for the victims of abuse in state care or, in other circumstances. And there's something wrong where people feel that they've got to defend the state, right or wrong. There's something fundamentally missing in that happens. So, so that's why I think, if they were required to, actively take account of the international human rights standards that we have willingly signed up to, that would put a different slant on things. I think it would engender a different behaviour, a different frame of mind, and it's certainly needed, absolutely. Otherwise, they'll continue just to blame. The people who get into trouble are the people who deserve it. That's basically, the approach now.
You talk about principles guiding public servants, the public service, and in your statement you referred to a human rights approach, particularly around, I think it was records and the voice of the effective having a say in decisions that affect them. sometimes, is there a role, sometimes human rights standards get lost in legality for understanding a human rights approach, some of the principles that sit behind that. Nothing about us without us.
Yeah.
What is the role in communicating something to the public that will help transform how we care in Aotearoa, New Zealand?
Yeah. Actually, that's a really good question. You're absolutely right. I think for too long human rights were equated with legal, constitutional or legal guarantees of human rights, and human rights were seen as something that were mostly defended in the courts, or could be taken to the courts to litigate. Whereas actually, having human rights make a difference in people's lives day to day. They're about how we treat each other. They're about what opportunities we have to grow and flourish. They're about whether we've got the basics for a decent life, which actually includes things like healthy, affordable housing and enough to eat. And those are, it's much more, the human rights, the impact of human rights, I think, is much more felt. I mean, the law's important, good to have the law, but actually it's really about what are the policies and what are the practices. And a human rights approach, as you say, is really a practical way of thinking about that. What are all the rights of everybody that we're looking at in a particular scenario? What are all the rights involved? How do we balance those? And a human rights approach says if you need to balance them, then they should be balanced in favour of the most vulnerable. And then how do the people who are directly affected participate in the decisions that affect them? Are they empowered? Is there accountability, which obviously has been missing, and is there non-discrimination? So these are it's not rocket science. And actually, again, people in the past, when we've explained this to them and with commission submissions and things, have said how helpful that having that sort of scheme to think through things has been, but it's not widespread. And of course, one of the problems is that for the most part, we don't incorporate the whole human rights covenant or convention in our legislation. Usually, there's references to it, or there's bits of it that are put in, but not, we don't put the whole covenant or convention, say, as an addendum to, in the case of the care of the Convention on the Rights of the Child, it is included as a whole, but it doesn't still have a status in its own right in our law. So, and lots of judges, of course, never learned anything about human rights or even the Bill of Rights Act when they were in their legal training. So it's a new thing for them as well. There's only a few that consistently you see in their decisions are looking at, what are the human rights issues here, or what are the treaty issues. So we need more of that at every level. But I think there are some things that can be done, to strengthen the law by more fully incorporating the standards as we ratify them, so they can be called on.
Thank you.
Thank you. Dr. Erueti.
Thank you, Mr. Chair. Tēnā koe, te rangatira. I guess we're limited time, so I'll just get straight to my main question, which is about redress, because it was a priority for your report in 2011. And you'll be aware that in 2018 there was a review carried out by MSD of the MSD historical claims process, which included looking at the role of tikanga in its process, tikanga Māori. And I'm wondering what you think of perhaps the best way to answer this is whether you think that review had an impact, and also what are the core qualities that you think are necessary for an effective redress scheme?
Well, I probably, the question about what impact it has probably better directed at the lawyers who've been representing, because I don't feel I've got enough knowledge of enough cases to make a general comment. In the, I'll just quickly find it and put it away, but in the report, we listed what we thought were the elements of a so we said, building on the strengths of the confidential listening and assistance service and the MSD care claims and resolution team, and the lessons learnt from the direct negotiations undertaken by both MSD and the Crown Health Financing Authority, the priority must be to establish an independent and impartial, in the fullest sense of the word, process to hear, investigate...
Noonan, the
yes.
speed.
Yes, I was looking at 5:25 and knowing you want to finish, sorry, my apologies.
Signers and the stenotyper.
I know. My mistake. Okay, so the process must apply to all claimants, regardless of whether their claim relates to psychiatric hospitals, social welfare homes or institutions, foster care arrangements or education facilities. So that's number one. Instead of having these disparate claims, there needs to be one process that applies. It must be one, and that gives the Crown reasonable assurance that allegations have substance. So, we never said people shouldn't have to provide some evidence, but what has happened until now is that, even though you've heard about Epuni, Hokio, Kohitere, Oaraka boys, etc., and we know now that even if you were not directly assaulted in one of those environments where bullying, etc., was widespread, you will have been affected as a child, seriously affected. So, so we're not saying that people should have to find records that show that they were actually hit, but if they were in the institution at the time where there is now overwhelming evidence of ill treatment generally, that should be sufficient. It needs to operate fairly and demonstrate good faith, provide claimants with access to an impartial advisory service, and so that's, drawing on the sort of thing that CLAS did, and does not leave claimants disadvantaged if there's no settlement, meet the various needs of claimants, including those looking for redress other than financial compensation, and those who cannot readily take part in traditional dispute resolution processes, leaves open the possibility of civil litigation where there's no settlement, allows individuals to be prosecuted, is not so rigorous or time-consuming as to render the process unattractive, and uses public resources efficiently. And we talk about drawing on international experience because one of the arguments most often used has been the fiscal risk to government, but in fact the Irish and Queensland responses showed that you can you can mitigate that risk by saying this is the big bag of money, and then that has to be what's available to all of the claimants. So those were the kind of elements and we don't see those available as yet as a group.
That's right, as yet.
As yet.
So I see the emphasis on independence, and also the report talked about the idea of streamlining the process. So instead of going to all these different MOH, MOE, MSD, it's a one-stop shop I understand. Thank you.
Yeah,
Thank you.
so that was and I think there was a few other bits and pieces, that we did, all findings must be published, at least in general terms, etc. So we did go into quite some detail about, what a really good process would look at. And again, looking at it now, looking at it now, it's still possible. It's not
Shouldn't be that difficult.
Thank you. Judge Shaw.
Thank you very much for your evidence, Ms Noonan. I just want to thank you for your tenacity on this issue. Your efforts go back a long way, and I hope you find that at least coming here today is some sense of achievement, at least an interim achievement, that we've got this far. But I think you are very much or largely responsible for the drive, so I want to acknowledge that, and thank you for your evidence.
Thank you.
Thank you. I have the privilege of the final comment, and I just wish to state for the record that your own particular broad knowledge of relevant items for the Royal Commission stand alongside your courage in expressing the views that you have, and what you have said and what you have provided will be of considerable interest and importance for the work of the Royal Commission. So thank you.
Thank you, Sir.
Mr. Chair, thank you very much. Thank you very much again, Ms Noonan.